Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Winter Holland-Levine, case number 24AP098. Representing the appellant, Winter Holland-Levine, is Attorney Sean Milligan, and representing the appellee, State of Vermont, is Attorney Darren Raleigh.
Thanks very much, and good morning, everybody. We'll hear from counsel for the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. My name is Attorney Sean P. Milligan, and I represent the appellant, Winter Holland-Levine.
Thank you.
The corpus delicti rule precludes a criminal defendant from being convicted based on their statements without admission of additional corroborating evidence. In this case, the state did not meet its burden in support of a 7553 hold without bail because there was insufficient corroborating evidence that would have allowed a fact finder to conclude Mr. Holland-Levine guilty beyond a reasonable doubt.
What is the standard for the corroborating evidence? How much does there have to be?
So we will acknowledge that this court's case law puts forward that there need only be slight corroboration. However, there needs to be some type of corroboration of the actual corpus of the crime. And here, we're saying that there is no corroborating evidence that there was a sexual act as defined by law, that being contact between certain body parts. In support of this contention, we have two primary arguments. One, that the state didn't meet its burden because the court had no ability to determine whether the often referenced video is sufficient corroborating evidence. And two, the state didn't meet its burden because references to a video or the video without more is insufficient corroboration. And finally, as put forth in brief, we submit that reversal is required because of the 27-day delay between the first and second portions of the weight of the evidence hearing. But focusing on the corpus.
Mr. Milligan, I want to ask you a question about the second issue first. The way I read the transcript is at the end of the March 28th hearing, which was the second hearing date, you didn't ask to hold the evidence open or anything of that nature. What you did was told the court that if the court held your client without bail, you would then file a motion with the court to have the so-called condition 4 supervisor looked at. So how do you argue that you preserved this argument?
Yes. So first, I would note that I pointed out the presence of our proposed condition 4 person at the first portion of the hearing. The court did not allow presentation of that person's testimony out of order. And then I brought up this issue at the second portion of the hearing, and I believe articulated the prejudice that it had to Mr. Holland-Levine. So understanding that what I requested from the court was an ability to file for bail review, essentially, should we be able to present that person or another. We do think that the delay here and the constitutional import that this court has articulated requires a quick turnaround on scheduling of these hearings, requires reversal. There's really no other meaningful remedy for Mr. Holland-Levine at this point based on that delay. And certainly the delay is not attributable to him.
This condition 4 person certainly was aware that there were proceedings underway and now has, for lack of a better term, absented themselves. Doesn't that suggest they're no longer interested in being the condition 4 person?
As I stated in brief, the last communication that my office had with this person was that they were still interested, and that was after the first portion of the hearing. So while we had an inability to present that person to the court, we have no reason to believe that they were no longer interested or no longer able to adhere to the requirements of a condition 4 person.
But doesn't the fact that they've been incommunicado with you since the first hearing suggest that they may be of a different mind at this point?
I think that that's one inference that could be taken from their absence in the proceedings. Certainly, as I've stated, I think that there are potentially other reasons, but it's really unknown why that person was no longer available by the second portion of the hearing. But turning back to my primary arguments, which are that application of the corpus delicti rule precludes the court from concluding that the evidence of guilt is great, I think it's important to look at the 12D standard within the context of Section 7553, weight of the evidence hearing. As put forth by this court in Bullock, there's two distinct inquiries. One, that substantial admissible evidence of guilt exists, and two, that the evidence can fairly and reasonably convince a fact finder that the defendant is guilty beyond a reasonable doubt. And because the court had no ability to determine whether the video that was referenced throughout the hearing was in fact corroborating or sufficiently corroborating, for that reason, the trial court's conclusion that the evidence of guilt is great requires reversal by this court.
Can't the defendant's statement be corroborated by the alleged victim's statement that she went to bed clothed, woke up unclothed, and the defendant was in the room with no clothes on? Would that be slight corroboration?
So we don't believe that that rises to this, the level of even slight corroboration. I believe that the statement that she went to bed with clothes on and woke up with clothes off, that could be offered as some corroboration. But I also believe that taken in context, her statements about her waking up and the defendant being present in the apartment and unclothed actually involved, I believe that there were two other women that were there. It wasn't an allegation where the sexual encounter was ongoing involving her, or that she was involved in any way. Really, is her statement, which lacks a lot of particularity or detail about what the actual allegation being made against the defendant is, really doesn't indicate that there was corroboration that a sexual act as defined by law occurred. So no, we don't believe that those statements or the information contained in the complainant statements is sufficient corroboration alone.
Would that information be admissible at trial?
I think it would depend, but ultimately that's the state's burden, and they would have to show that it would be admissible at trial. And I don't think that based on the state's evidentiary presentation below, that they have displayed that that would be sufficient. So we would note, again, as I was saying, that the complainant's statement really lacks any type of particularity, doesn't indicate what was on the video. And ultimately, this is what we're getting at, is the only sufficient corroborating evidence of the allegation here is the video, which was not admitted. The court had no ability to analyze its contents, and that therefore we're really just left with the statements from the two parties.
And didn't the I know it's a fine line, but didn't the defendant, I just now watched the video several minutes ago, and didn't the defendant confirm in his statement that he made a video and that what he describes during his interview as happening is on the video? And if that's the case, can't the court consider that?
So
the fact that there's a video and the defendant described making contact under the statute, described under the statute, and that was on the video.
So first, I actually don't agree that the defendant's statements indicate that the sexual act, the contact between body parts, occurred on video. That's based on my review. I don't believe what is said.
But you, in your brief, you said that you concede that his statements satisfy all the elements of the offense, but that there's not corroboration.
Correct. So I think that there are several statements made by the defendant which, without application of the 12D standard or the corpus delicti rule, would meet the definition. of a sexual act. However, there needs to be some corroboration of his statements. His statements can't be corroborating of themselves. So while he indicates that there is a video that he took, what's not before the court is what that video depicts and whether it depicts the acts that would constitute a sexual act as defined by law. And in support of this first argument, I do just want to add that the court found, and I'm quoting from the decision, that the officer had in fact reviewed the video before interviewing the defendant, confirming that the defendant had videoed a portion of the encounter on BD's phone. However, the detective's testimony did not say that. He confirmed that he had watched the video at some point in time, but that he had not watched it with the defendant, and there's no indication that he watched it before the interview. So I don't think that the trial court can even conclude that there was sufficient evidence to conclude that the defendant and the officers were necessarily talking about the same video. Both the defendant and the complainant talk about multiple videos, potentially involving other individuals, and there's no indication, no confirmation that the references in the defendant's interview with law enforcement that the parties were all talking about the same video. So, and beyond that, and this is more in support of the second argument that I plan on making, but the officer's statements in the interview video, the video depicting the interview between the defendant and law enforcement, the officer statements therein are not admissible evidence. I objected to the court's consideration of any hearsay on those videos, and particularly referenced the officer's statements or questioning of the defendant. And the state, I believe, agreed on the record at the trial court level, as well as in their briefing, that hearsay statements would be excluded from that the court's consideration of that exhibit. So I don't think that the court could base any findings on the statements made by law enforcement. The court was really restricted to the statements made by defendant on that video. But turning to that second argument, that references to quote unquote the video without more is insufficient corroborating evidence that would allow a fact finder to conclude the defendant is guilty beyond a reasonable doubt. The court found that there was sufficient evidence of what the video depicts. However, the court's factual findings in support of that conclusion are really not supported by the record. I just pointed out the court's conclusion that the officer had viewed the video before interviewing the defendant. That is not supported by the record. Again, Detective Menjivar only testified that he had viewed the Detective Menjivar had viewed the video at some point prior to testifying at the weight of the evidence hearing. But
Mr. Milligan, can I interrupt you? You haven't made any objections to any of the factual findings by the court in your brief or your memo, except as to whether he had the opportunity to see the video and then make findings on it, correct? You haven't made any other objections to factual or challenges to factual findings.
I do think that that is tacitly what I'm arguing in support of my arguments in the brief. And here on the record, I am objecting to the court's factual finding that the officer had viewed the video before interviewing the defendant. I don't think that that conclusion is supported by the evidence in this case. So I do object to the court's findings that the officer had viewed the video before the interview with the defendant, and that there is sufficient evidence to conclude that the parties were talking about the same video during that interview. We would also object to the court's conclusion that BD had learned that there was a video showing what happened. Again, her statement—
You have 1 minute, counsel. You have 1 minute.
Thank you. Her statement does not really indicate what the allegation is specifically. Certainly, not what is depicted on the video, which is really her basis of the knowledge of anything that had happened. And therefore, the court is really only left with defendant's statements upon which it can make factual findings regarding the necessary elements here. So this is exactly the type of the case where the corpus delicti rule applies, and therefore the state did not meet its burden. I'd like to reserve what little time I have left for rebuttal.
Thank you very much. We'll hear from counsel for the appellee now. Please introduce yourself, identify your client, and then proceed.
Good morning, Chief Justice Reiber, Justice Eaton, Justice Carroll. My name is Darren Raleigh, and I represent the state of Vermont, the appellee. The purpose of the corpus delicti, Your Honors, is to foreclose the possibility of a conviction based on a false confession where, in fact, no crime had been committed. The case law related to corpus delicti is well established, and the threshold is quite low. There must be some independent evidence, but appellant fails to recognize that evidence need not independently prove the commission of the crime beyond a reasonable doubt. So what we are considering is just corroborating evidence. It's not corroborating evidence that would prove the crime without the defendant's admissions. As this court held in State of Vermont versus Weller, slight corroboration is sufficient. Determination of whether or not that corroborating evidence is sufficient is the province of the court, and the trial court made a determination here that it was sufficient. The sworn statement of the alleged victim, BD, which is admissible at a weight of the evidence hearing, contains the following corroborating statements. BD identifies the defendant by his name, Winter, as being in her residence naked when she woke up. She states that she woke up in her bed with her pants around her ankles. She states that she had gone to bed at about 1 or 2 a.m. after having taken several sedative or prescription medications. Those statements taken together with the defendant's confession are more than sufficient to overcome the corpus delicti challenge. None of those statements are direct evidence of the crime, but they don't need to be. It is entirely fair and possible for the state to prove its case beyond a reasonable doubt on circumstantial evidence alone. BD does not have to have remembered the sexual assault in order to provide circumstantial evidence that a sexual act occurred. And it's worth noting, Your Honors, that the charge itself contains language that the defendant either committed the sexual act or attempted to commit the sexual act. BD's pants being around her ankles certainly are circumstantial, or certainly is circumstantial evidence that a sexual act either was committed or had been attempted. So furthermore, the trial court was right to consider the existence of the cell phone video that BD talks about, that the officer talked about, and that the defendant identified in his confession to Officer or Detective Menjivar. The state is not obligated to admit every single piece of evidence at a 12D or weight of the evidence hearing. The testimonial evidence from the officers, from the sworn statement of BD that came in through Officer Parker's body-worn camera, and the statement from the defendant to Detective Menjivar was enough to lay the foundation that the video would be admissible at trial. And in that vein, Your Honors, authentication can be established through a piece of evidence being particularly unique, that it is the thing that the state is purporting that it is. The issue at trial would be an issue of weight. It would not be an issue of admissibility. So it is proper for the trial court to have considered it, because the language in 12D specifically states that the state must establish that it has substantial admissible evidence, not that the state has to admit that evidence. Even if the trial court was wrong in considering that video or what was purported to be on the video, the state still submits that there was enough in BD's statement to corroborate the defendant's confession. Considering these facts in relation to Weller, where the only corroboration to the defendant's multiple confessions was that the state's arson investigator ruled that the fire was of a criminal nature. There was nothing placing the defendant in that case at the scene of the crime. Here, BD places the defendant in her apartment after the commission of the crime that he confesses to. BD's statement that she woke up with her pants around her ankles is corroborative of a sexual assault or an attempted sexual assault having occurred. BD's statement that she took several sedative prescription medications is corroborative that any sexual act that could have occurred would not have been consensual. And those establish both parts of the corpus of this crime. But frankly, they don't need to. It is only slight corroboration that is required. Again, it is not that those corroborating statements have to independently prove the crime beyond a reasonable doubt. The trial court's decision to hold the defendant without bail should be affirmed because the corroborating evidence from BD's statement establishes that the evidence of guilt is great in conjunction with the defendant's confession. Again, we're considering this pursuant to a 12D standard, taking the evidence in the light most favorable to the state, excluding modifying evidence. A reasonable juror certainly could convict the defendant beyond a reasonable doubt based on these statements and the defendant's confessions, and this evidence is more than enough to withstand a motion for a judgment of acquittal. All of the evidence after it is considered is for a fact finder. Finally, the state wishes to touch upon defendant's argument that the trial court unduly prejudiced the defendant in scheduling the continuation of this hearing for 27 days after the original hearing. The state would note, as it did in its memorandum, that there were numerous court hearings in the Rutland Criminal Division between March 1st and March 28th. The Rutland Criminal Division was about as busy as it could have been. The scheduled hearing, or the second part of this hearing, was scheduled as promptly as it could have been. As soon as jury trial dates opened up after jury draw, this continuation was scheduled. And moreover, the state wishes to also highlight that the witness was present at the first part of the hearing, that she knew that the hearing had been continued, and that she failed to keep defense counsel updated about her contact information. As such, that is not a prejudice due to the court. That condition for a person either becoming unreliable or deciding that she didn't want to participate in the hearing when it was continued. It is not the court's prejudice, and the state does not believe that there was any undue burden. With that in mind, the state will rest on its memorandum and the record that is before the court. The state respectfully asks that the court affirm the trial court's decision holding the defendant without bail.
Okay, thank you very much. How much time does the appellant have, please?
Appellant has 19 seconds remaining.
Counsel?
I would take the few seconds that I have left to rebuff the state's assertion that there was a sufficient foundation for admissibility of the video had it been at trial. I don't think that there was a sufficient basis under this court's decision under State v. Hiltel, and for that reason, in addition to the others that I've argued, the trial court should not have considered the existence of the video and cannot conclude that it is sufficiently corroborating.
Okay, thank you very much. Your time has expired. Please call a